The prosecution has rested its case in the Karen Read retrial. Hi, everybody. I'm Kristina Rex. I'm joined today by our legal analyst, Katherine Loftus.
Nice to see you.
Nice to see you, too, a.k.a. Note My Objection.
That's right.
So 23 days of testimony, 38 witnesses, and the Commonwealth has rested its case. So what that means for anybody watching is that the state's case, prosecutor's case, is now done. Now the defense gets its turn at presenting a case. So Katherine and I are going to go over basically the highlights of the prosecution's case and kind of an overview. But I want to start with you at the very end. So this just happened a couple of hours ago that the prosecution rested. And we just want to show our viewers the very last thing that the jury saw before the prosecution rested. Here it is.
So I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he was drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
So right after the final witness, that clip, it's about 45 seconds or so, was played for the jury, in which Karen Read talks about asking her attorney the night that this happened, you know, about 12 or so hours after this happened, what if I clipped him? What if I hit him in the knee? And her lawyer, she says, tells her she could have had some element of culpability. What are your thoughts on that interview clip, as well as prosecutor's choice to make it the last thing the jury sees?
Well, I think it was Attorney Brennan's way of sort of wrapping up all of the pieces of evidence that we have seen presented. We've seen a number of clips of Miss Read. You know, there's never really been a denial that she said some form of, I hit him, could I have hit him? But this is really a substantive sort of recitation from her about what she was actually thinking that day. You know, so on January 29th, and when she was calling David Yannetti, she was actually thinking herself, could I have hit him? Could I have clipped him? You know, speaking to an attorney saying, if I did this, is there some level of culpability? So I think what it does for the Commonwealth is her own words in a way sort of bolster what they have presented through not only the civilian witnesses and what they heard and observed, but also the technical witnesses leading up through the last civilian witness that we had here today, Dr. Welcher. And I think it was, it really goes to how consequential some of her statements in these interviews that she has given to various media outlets may just be in sort of the entirety of the Commonwealth's case when the jury looks at them. Most, you know, sort of interesting is that there is a little bit more context to that clip. In the video, in the documentary, she actually explains that this is why I thought, you know, I could have hit him for the first couple of days until, you know, there's this call that they allegedly get. That doesn't come into court. So the jury only gets what Attorney Brennan presents, and the defense really doesn't have an ability to put that statement into context unless they call her, which just seems pretty unlikely. So it's pretty powerful from the Commonwealth's perspective.
Right, they would have to call Karen Read to the stand.
That's correct.
To counter that. Okay, so I want to go into a little bit of an overview now. Again, this is just the state's case. They've been the only ones presenting. Let's talk about what's different. Obviously, one of the biggest differences here is that there's a new prosecutor. There's a special prosecutor, Hank Brennan, who's been the lead prosecutor on this case. There are also about half the amount of witnesses, 38 witnesses versus 68 the Commonwealth called in the first trial. So what do you think that difference is? The difference that both Hank Brennan has brought and just the different strategy we've seen? Well, I think it just goes to show that different attorneys think about cases differently, right? So you might have a set of prosecutors who all look at the same sort of underlying set of facts and think about, okay, this is the best way that I think to present the case and prove it. Because ultimately the Commonwealth's job is to prove Karen Read guilty beyond a reasonable doubt of the charges that they have against her. And what Attorney Brennan brings to the table is an experience on both sides. He was a prosecutor early in his career, but really has spent quite a bit of time on the defense side. And so it allows him the ability to think a little bit differently than some, you know, maybe ADA Lally or McLaughlin who have been prosecutors and only prosecutors their whole career. Because what Attorney Brennan knows is how he would defend this case. He knows how he would attack it. And so in knowing that,
being able to sort of circumvent what the defense theory or tactics might be by spearheading, presenting less witnesses. For example, in the first trial, Adam Lally presented a number of civilian witnesses that effectively were just fodder for the defense. That once they got up there, they were, aggressively cross-examined. Their stories were picked apart, and they really didn't provide any help to the Commonwealth. In this trial number 2, what Attorney Brennan did is sort of take all of that out, that there was no real fluff to the case. There wasn't anything extra outside of what he believes he needed to present in order to prove the charges against her. So I think it really just gives some context into how different, depending on the set of eyes looking at the case and what the experience is, what they think the necessary way to prove the case is. And so ultimately, I think that Attorney Brennan was a strength for the Commonwealth to bring in.
Yeah, and you talked, I think the way you've summarized it before is almost like in the first trial, the prosecution was playing defense in the beginning.
Right. That's right. And it really felt a lot like that. I think most observers was that they were trying to not only prove their case, but even more so it appeared that they were trying to disprove the defense theory.
Right.
And at that time, there was so much going on online. There was a lot of, public sort of outrage. And so I think the DA's office really sort of played into that too much and got distracted from what their job should be. The job is not to disprove what the defense says. Their job is to prove the case. If you believe you have a case against Karen Read, your job is to present it as efficiently as possible. And so I think that Attorney Brennan, by taking out a lot of that extra, most of those, if we think about the fact that we didn't hear from the vast majority of people in the House that night versus trial number 1 where we heard from all of them, they mostly offered duplicative testimony. And so what purpose would that serve for the Commonwealth outside of allowing the defense to cross-examine them and potentially poke holes? And so it's very strategic in the way I think Attorney Brennan presented the case, because not only is he trying to prove his case for the Commonwealth, but also trying to box the defense into maybe making it a little bit harder to present this third-party planting theory without all of those witnesses being called in the case in chief.
Well, on that note, and we'll get more into the third-party theory later, but just generally speaking, right now, what does the jury know about that third-party theory? I mean, have they gotten any evidence or testimony about John O'Keefe potentially going in the house or evidence being planted? There's been some questions on cross and someone redirect, but I'm not sure.
No, and I don't know that, all of us who are watching know that the questions that they asked of some of the witnesses, relative to Michael Proctor and the Sally Port, and to Uri Buchanan about the chain of custody and when things were recovered, the taillight pieces at the scene, and then even with Ann Whiffen when they talked about sort of the general area in which, while he believed John O'Keefe's phone didn't leave essentially the flagpole area, there's a bigger sort of perimeter that theoretically, John could make it made it inside, but they have never taken that next leap. They've sort of planted seeds into the jury's mind through the cross-examination. But at this point, if they want to argue third party, if they want to get that jury instruction, which ultimately is what the goal is that at the end of the case, when the defense has rested and it goes to the jury, that if you want to point the finger in your closing argument at a third party, Brian Albert, Brian Higgins, somebody else, you have to have produced sufficient evidence for that jury instruction to be warranted. At this point, we have not reached that. So the question now becomes, do they present those witnesses in that case in chief? And is it, it's an interesting strategical decision as to which way they're going to go.
We'll get more into that later. But first, one last topic for right now is a big focus for our conversations in the prosecution's case has been who they didn't call. Most notably, former trooper Michael Proctor, Brian Higgins, and Brian Albert. So the 2 alleged third-party culprits and the lead investigator who got fired ultimately over his conduct in this case.
That's right.
So, I mean, you predicted it. You were right. They didn't get called by the prosecution. Can you just talk about why that is and if you think it was the right move?
Well, I think ultimately, if you think about what you have to prove for the various prongs of each of the charges. So she's charged with second-degree murder, manslaughter, and leaving the scene. What the Commonwealth looks at and what Attorney Brennan looks at is, okay, if I call Brian Higgins, what does he actually add to the case? What does he provide that helps me prove my case? Nothing. What does Brian Albert provide that helps me prove my case? Nothing. And
Only John didn't go in the house.
Only John didn't go in the house.
Right.
And what he did was, by not only, he essentially, without calling these, by not calling these people, he has precluded the defense from arguing it through the witnesses on cross-examination.
Okay.
And so if you think about that, you know that this might be the defense theory and that you don't need them to prove your case, why would you call them on behalf of the Commonwealth, right? Because you know they're essentially just going to get up there. They're not going to provide you, if there was some sort of evidentiary value to either of their testimony that would prove one of the elements, you would have to call them. But why essentially set them up to be cross-examined and help the defense? So it's really, I mean, you have to think about strategy is a huge part of trial, and what we see in court from both the prosecution and the defense is very, very well thought out.
Yep.
And so, if you don't think they're going to help your case, don't call them.
Really quick before we take a break, Proctor in particular. Yuri Buchanan, who is a sergeant on the case as well, he testified a lot about things that he did with Trooper Proctor, almost as a cover or a surrogate for Michael Proctor. What do you think? Proctor's name has come up so much already. What do you think the jury is thinking of him right now?
I mean, I think that it's clear from the testimony, anyone who was questioned on him, that something happened with Michael Proctor relative to this case. I think that's a fair assumption that the jurors could draw at this point. They don't know the specifics. They don't know what he was alleged to have done. They really only have these crumbs from the defense in the questioning of really Yuri Buchanan. But, from the Commonwealth's perspective, really what I think they look at, it's the reason mostly police work in tandems, is that if something comes up with one individual, the other one can testify to it. And so from a strategic point, it's really interesting that they, it's a risk, because then the defense gets to argue, hey, the Commonwealth didn't even call their lead investigator. What should you draw from that? The Commonwealth's hope is that despite any problems that Michael Proctor has, that the evidence, physical evidence in the testimony is sufficient to overcome that burden.
Interesting. All right, we're going to take a quick break, and we will be right back with more analysis. The prosecution has just rested its case in Karen Read's retrial, and we're back with a bit more analysis about the prosecution's entire case. I'm joined by Katherine Loftus, our legal analyst. Thanks again.
Thanks for having me.
Next thing I want to talk about with you are who we might consider to be the key witnesses from the prosecution's case this time around, unlike the first time around. We wrote some down, brainstormed a little. Let's start with Jen McCabe and Kerry Roberts. Talk about them together. They testified in both trials, but what role do you feel they played in this trial?
I think they played the role of sort of not only humanizing John O'Keefe, but in a way, Karen Read, describing what actually happened that morning, these frantic calls that they're getting, because there's a lot of technical data that comes into this case. So the Commonwealth wants to remind the jury that, these are real people, these are real emotions, there was a lot happening at the time. And they also will point out that Kerry Roberts and Jen McCabe, despite both having close relationships with John O'Keefe, actually weren't really in contact with each other.
Yeah, they didn't really know each other.
No, they didn't really know each other. They had, sort of mutual acquaintances, but their children were different ages, and so they were, Jen McCabe was more familiar with Kaylee, Kerry Roberts with Patrick, but the point of those two women's, the women's testimony is to show that they're substantially the same. And these are two different individuals. It's not like they were, Kerry Roberts wasn't at the party that night before. She wasn't at the bar. She was called essentially out of the blue the morning of. And what she testifies to is virtually the same as what Jen McCabe testifies to, which gives their testimony more of an air of credibility. And that's what you're always looking at as a lawyer, is that when you're presenting witnesses, you want to not only have the jury believe the witness in front of you, but you want other witnesses to bolster that credibility. And so, there was a little bit of, questioning about, who told you this to Jen McCabe and Kerry Roberts, were you in her ear? Sort of this suggestion that there was maybe
was it bolstering or was it influencing testimony?
Right, that's right. And so I think there was some sort of points that were made by the defense, but it's interesting, they was called so long ago. It's almost like, how much of that does the jury retain? So I think that in terms of framing the morning of, the chaoticness of it, and sort of how frantic Karen Reed was, the statements she made, did he get hit by a plow, John's dead, those kinds of things, are important to the Commonwealth's case as a whole.
And you've pointed out, too, not only did these women not really know each other before this, but also, even compared to everyone who's in the house or everyone who's around that night, they were the closest with John O'Keefe, like actual friends of his, compared to Brian Higgins, who was kind of friends with him.
Right, and so I think it's important to note, and it'll be interesting to see whether Attorney Brennan sort of hones in on this in his closing argument, that these two women were people who John O'Keefe really relied on in his real life. When he took custody of these kids, he's a single guy from Dorchester, changes basically his whole life to become a dad. And these women were the two who helped him, take the kids out, sleepovers, give him a break. And who did Karen Reed call that morning? She's not calling her friends. She's not calling, her mom or dad later to come. She's calling John's friends. And what did those two women do? They got up in the morning at 5 o'clock in the middle of a blizzard, and they came to help. So, I think that it goes to just sort of the bigger picture of who John was, who he valued in his life, who he looked to for help raising those kids. And at that time, things have certainly changed in the perception of Miss Reed, of both Kerry Roberts and Jen McKay. But at that time, she looked to them for help as well. So, I think it's an important point for the Commonwealth.
Okay, next, we've talked about him a little bit, but I want to talk about Yuri Buchanan again. He's a state trooper. He's still working in his capacity, but he was essentially partners with Michael Proctor.
Right.
And also Michael Proctor's supervisor, I believe, at one point.
And a little incestuous.
Yes, it's like, I'm not sure what their roles were at any given point, but he did the bulk of this investigation with Michael Proctor. And he also testified, as we've discussed, not only on behalf of Proctor, who didn't testify, but also on behalf of Brian Higgins.
That's right.
On still kind of a stunning moment in this case, which is that on cross-examination, Yuri Buchanan read all of Karen Reed's and Brian Higgins' text messages.
That's right.
Talk about, A, why he was allowed to do that,
Yep.
and B, why the defense wanted that to happen.
So I think he was allowed to do that because the statements of the defendant, and so they're allowed to come in there through the hearsay exception, and he's one of the individuals as the detective who had access to that information that was downloaded from John O'Keefe's phone. So he was able to testify to it that way. The interesting question, I'm not sure how helpful it was to the defense overall. I think that calling Yuri and having him testify as to Mr. Higgins and Ms. Reed's text, it provided a little bit of where they wanted to go for the defense with the third party, because they want to be able to point the finger. Again, as trial is progressing, sometimes you have this sort of goal of, okay, we're going to go third party.
Yep.
I don't know that's where we are now, but I think at that moment in time when Yuri Buchanan was on the stand, that was still sort of a live sort of goal of the defense.
Well, they must have known Higgins wasn't getting called, too.
That's correct. And so they want to be able to say, okay, there's something else going on here. You didn't investigate this. You didn't look further into it. I'm not sure that the reading of the text messages was helpful to their client. And, it's sort of a pretty tenuous connection to, could this person potentially have a motive to kill John O'Keefe because he was in sort of a flirtatious relationship with Miss Reed? I would say that was probably one of the rare misses for the defense, to be honest. And
then the defense also showed that Canton surveillance footage of Brian Higgins showing up back to the Canton police station, walking the halls, going to his office. Unclear if he actually moved cars like he said he was going to, but he was like turning cars on and off. What do you think the jury gleaned from that, if anything?
I would imagine they were probably confused more than anything, because the difficulty, so as we talked about, the first trial, this was sort of a layup for the defense, right? Because the prosecution's almost served it on a platter for them. Here are all the witnesses, attack them with whatever you want.
Right.
And so you had Brian Higgins on the stand where, he's under a rigorous cross-examination, you did this, you did that, and trying to paint this picture of him as a person who could potentially be another culprit. In this case, we have a state police sergeant who's reading text messages, and then we have a video of this person who we've never really heard about outside of very loosely, maybe
and
once or twice.
We have the context only from the first trial.
That's correct.
About him going to the police station.
Right. And so the jury here doesn't even have that context. So they're looking at who is this guy that's going to the police station, and what are we supposed to glean from it? Because we haven't heard, prior to that, they hadn't heard anything substantively about what they're supposed to be thinking. So that's the question, is whether the defense now, in their case in chief, is going to maybe potentially call Brian Higgins or use somebody else to try to point the finger at him, if they'll sort of wrap that up, that box that they opened.
Okay. Very quickly, let's go to Lieutenant O'Hara from the CERT team. I believe, if I remember correctly, to you, he was a standout witness.
I thought trial number one, and I think same as trial number two, he is probably one of the most important witnesses because, he's an individual. For those who don't know, Lieutenant O'Hara is in charge of the CERT team, SERT, which is basically the search team for the entire state police. So they found
the first pieces of tail.
That's correct. Yeah. And they just get called in. They don't have anything to do with this. Yeah. They're not assigned to the Norfolk DA's office. They come from all different parts of the state. They come, establish the scene. And what he does is he establishes the timeline in which he first arrived. I think it was 4:56 was the first state police trooper. That's all marked by the GPSs in their cruisers. And essentially, establishes the crime scene and says nobody comes in at this point, and they find not only multiple pieces of taillight, but they also find John O'Keefe's sneaker, which is sort of compacted underneath the snow up against the curb. In trial number one, it's the only question that the jury asked. They asked for the CERT team report. And so they went out of everything they heard, they went right back to the physical evidence. And I think, I think he was a strong witness. He didn't falter, and it's hard to point to him and say, he's wrong.
Okay, two other topics of witnesses. First one, the most recent, Aperture. This is the group that the Commonwealth has paid allegedly over $300,000 to.
A lot of money.
A lot of money for their independent services to basically figure out what happened. Was there a car crash? What time? When? Look at all the data. Your overall take on them, because there were two witnesses and both were quite contentious at points.
Yeah. So we had Shannon Burgess, who's the data analyst, and was dealing with the sort of the lining up of the different data, the Waze data, John O'Keefe's phone, the Lexus, and then we had Dr. Judson Welcher, who is the accident reconstructionist. He used Mr. Burgess's some of that data, as well as a voluminous amount of data that was turned over by the DA's office in order to recreate what he believes happened. I think they were both, I think that Dr. Welcher was probably better on the stand than, in some ways, substantively. He was a little more contentious going back and forth with Attorney Alessi, but I think that he really stood by what his ultimate opinion was, which was that this type of Lexus could have caused the injuries to John O'Keefe. The defense did certainly have some wins with these witnesses, more so Shannon Burgess. Obviously, we heard about his credentials, what his CV looked like. Did he actually have a bachelor's? Did he ever have it? Why was it put on some? And that goes to ultimately the credibility of a witness. And so the defense certainly made some inroads with Mr. Burgess. But I do think from what the Commonwealth tried to do with Aperture was take all of the reason why he was last was because everything that had been presented, we still had never heard, what do you actually think happened?
Yeah.
And he was able to tie all of those pieces of data together to say, we think that John O'Keefe was hit by Karen Reed's vehicle.
Okay, we don't have a ton of time left, so I'm going to fly through one other thing. We discussed Ian Whiffen and Jessica Hyde. Basically, that, in your opinion, and correct me if I'm wrong, they are the only witnesses who were called for defensive purposes to defend the alleged 227 How Long to Die in the Google search.
That's right. So I think that's the only thing that Hank Brennan to really to rebut what the defense might potentially say.
Yeah.
So the 227 Google search, which is sort of the infamous Google search that really started all of the sort of public outcry about this case.
Yep.
And both Ann Whiffen and Jessica Hyde testified that that was an incorrect interpretation of the data by Richard Green, that Richard Green had actually reached out to Ann Whiffen. So again, it'll be interesting to see, do they call Richard Green? Do they try to go down this route of 227? Or do they stick with the Bowden defense and the police, substandard investigation and try to just poke the holes in the reasonable doubt? So it'll be interesting.
Very last question. What do you think? Obviously, the defense's case is going to start on Friday. What do you think we can expect from the defense this time? And in particular, I'm curious about Alan Jackson, who has really taken a back seat so far compared to the first trial.
I think he's probably going to take the majority of the defense case. And we heard from Miss Reed outside of the court, I think it was earlier this week, and she said it was going to be a little bit more voluminous than it was last time. I think it was only 2 or 3 days that they presented.
6 witnesses last time. That's
6 witnesses. So we don't know. Will we hear from Dr. Russell, the dog expert? They have another canine bite expert. They really have 2 potential ways they can go, and we might know right off the bat as soon as we see who the first witness is, whether they are going to go, with what they did trial number 1, which was this framing, third party, point the fingers, or if they're really going to focus on the police, Michael Proctor, conflict of interest, substandard, you can't find her guilty.
And we'll find out soon.
We shall.
Thank you so much, as always, and we'll do another one of these once the defense wraps as well. Thanks, everybody.